of grace this morning hour. Submit the witness that will be before us, that you grant him the boldness to be able to speak the truth, and grant the commission the discerning spirit to discern between truth and falsehood. And we continue to ask that you grant the populace, the diaspora, and the international community, grant them the extraordinary patience to allow the due process to take its proper course. And you, being the just judge, will reward each and everyone accordingly. This we ask through Christ our Lord. Amen.
Amen. Thank you very much, Bishop Odeko. Council, I believe we are continuing with our focus on the justice sector institutions. That is the case, and you're ready with the witness this morning. You may please proceed.
Good morning, Mr. Chairman, and good morning, commissioners and members of the audience. Yes, we are ready to proceed with our next witness, and we are continuing with the justice sector reforms today. Thank you.
Thank you.
I, BORRY S. TOURAY.
I, BORRY S. TOURAY.
Do swear that.
Do swear.
I'll speak the truth.
That I'll speak the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
So help me God.
So help me God.
Thank
you. Good morning, Mr. Touré.
Good morning, everyone.
Isama, Mr. Touré.
Good morning, Isama.
Isama.
Isama, alhamdulillah. Good morning, commissioners. And good morning, members of the TRRC.
Isama, Commissioner, Isama, TRRC Nkolu.
Thank you very much, Mr. Touré. I have the singular pleasure of welcoming my learned senior today before the commission.
Thank you so much.
Inumbara.
We thank you for honoring our invitation at very short notice.
I'm grateful indeed.
And I also have the unusual opportunity and privilege to guide Mr. Touré, who is my learned senior, in his testimony.
And kabi nyingetanye site sewoti amealonko aman dalikake puru ngatambi na nyaronko nyaro puru mealonko loyal karola puru ka tete nyi sedandro nyinkon.
I'm grateful indeed.
Aketanye nyaboti.
Please make yourself comfortable.
Okay, thank you so much.
And during the course of your testimony, keep in mind that we have interpretations going on in the background.
I'm grateful indeed.
In your testimony today, we would like to hear about your experience as a magistrate,
belaf la purka moy fan bulu tumala menna e mun kiditela de dumalankoti ba fala me magistrate,
You were a former magistrate just after the military government took over in 1994.
Iketa kiti telari ba flame magistrate tariyarin ke kabrin mansakunda falon kera memu tuta in 1994 kudedari bodala.
Focusing more on political interference into the judiciary.
Andung benyatil na bake men kono wala ngindi ko politiko la karola ke dabula judiciary men kera kiti bundal la fannati.
By way of executive directives, intimidation.
Andung aka kenyame wala ngindi ko kangola ka bonan santo wala mansakunda la santo la bala multi kana ke dabula ko nyin kono.
Show of power and force and other undue influence. Consequently resulting in human rights violations. And in doing so, we will explore the following areas. We would like you to tell us if you know or if you have experience on how JAME used the judiciary and other justice sector institutions.
Belafla for Ninga Yalong, Yaya Jame aka Tilingo Bunda, aka Dabula Nyadile and Aka Tamandi Nyadila Purka Alakango Tamandi.
Such as the Ministry of Justice,
Abeokono Ministry Member Lual in Kirin Rukunyala,
the Gambia Police Force,
Na Police Kunda,
the Prisons Department,
Na Kasabunda,
to achieve his own personal agenda and thereby perpetuate and entrench himself in power. How JAME used punitive laws to persecute his political opponents, critics,
puruka adonyol me alonko wala ma jawol ti ala mira loto puruka wol kitindi ke dete
and other perceived threats to his administration and power.
Anu ngatela jikoro wala nyindi dolbe kala maslangol ti ala semboto anen ala maraloto.
And how people were routinely, falsely and maliciously prosecuted under the criminal code using such laws.
Anu akeno ta nyaadi le mol me alonko igana tumiro le kan faniya kono me alonko anen tilim manta pour que kitindi tilim baliya kan menni luwa manta luwal koto luwa kurungol koto.
We would also like to know about the abuse of the Ministry of Justice.
Anen kabi mbela fla fanan ka alon ministry member ni luwal ni kitindi kunya la tambol me alonko wala kete la fannala.
In particular, the manipulation of the Office of the Director of Public Prosecutions, DPP.
Andu abe kono wolem director me alon ko wolem marlin kitindir lal bela nyaton ko mebe ministry me marlin walin kitindir kunyala me alon ko ika yelamandi ila kul yelamandi nyamen ka kenyala me alon ko wole bate di ala diani ko woti ka timmandi
in order to target political opponents.
Ingamale isaja ala jikoro menu matela opposition wolti pour kawol daling ka kulawol kan
through politically motivated prosecutions on bogus charges.
Andu kaka nyame wala nyindi ko ka politika tumiro la mol kan rom politiko la karola isaje nyin kamala telafta menerom pour ka timmandi atela karola.
After you became a magistrate, you went into private practice and you have extensive experience as well.
Biringi kibota kake kitindirla ti dumalanga kitindirla e ba forme magistrate na na e ura e kitata na to do ko ke ifaye andu ila do ko nyin kono e londi sahari ngosota do ko nyin kono le
on some of the criminal and civil cases that you took for clients.
Andung ika cases dol menta me alon ko dammani damma cases le modi ba from civil matters dol be je on kuriya cases le ka me criminal yota kilianol toyala
in which you witnessed human rights violations as well during those cases.
Da menta yalon ko ila cases me alon ko yeta ila kilianol toyala ya hanabadi nyanta tinyal men je ko kono iso fanamfo.
So we would look at perhaps imposition of unrealistic bail conditions, for example. And the blatant disregard for established, court and legal procedure. And you also have extensive experience dealing with land matters.
And we are londo fanan sort of wala kene nyindamma kene fitinol fana me alon ko wala ka dum molda malte ma yelondo soro fanan ko to bakele
from the district tribunal all the way up to the Supreme Court.
Abon na yin sefu kiti bundal do kata fo kiti bumbala sandon ko to mbika me Supreme Court.
If you have any examples of how the office of the sheriff at the High Court was interfered with and manipulated.
Ninga etara yellondo so do bundala me yalon ko be kitindiri bunda do ba fala me sheriff division me yalon ko wolle be katara marale ninga etara kiti e kunturo ke kula me yalon ko tamandiro nyana kelo bundar men ka ko nyin tamandi ninga etara londi so foro ko ikay muna fa office of fanana nyame pour kal sembola mul kan.
Especially in relation to the sale of forfeited property for the benefit of Jammeh.
Surtout abe ko ninga etara kiti e kunturo ke ko kula me yalon ko nyim dingira kar nyanna wafila le me yalon ko sobobe je ko yaya Jammeh ay sulo so ra ko nyin konole.
Bribery of judges and witnesses to secure criminal convictions.
Aninka jojol ta wolem kiti bunda sandon ko kiti la sandon ko de keta ke duku aninka kisedol ta fananka kudum ida ko no waranto ka fendila pour yena kuma fo me yalon ko be diala mansaye.
And the removal of public officials who were no longer in the good books of Jammeh.
Jamala do kulal fana memo mansakunda do kulal te ke bondi la do ku palasol to nyin kamala ko ini yaya Jammeh mandra ni fanna keling mirodo.
We also have politically motivated constitutional amendments to entrench Jammeh in power.
Ko hannin kabi fananga loi buku bani fanan kono nga je fanan je ko falen do dol keta jel me yalon ko ya ke dalilo men kam wala nyindi ko pour ya Jammeh don ata dianye ko nyin pour ka o se won ka o timmandi don ay o falen dol men keta buko nyin kono.
And this is just a guide.
Ni mukula don pour nga fale don pour nga ngete ala ila sedan do nyin kono.
However, if you have other examples
Hannin kabi o nyaaw fanan ninga tre misalo dol fanan soro
how the justice sector institutions were used by Jammeh.
Akeno ranyadi na tilingo bunda nying ye yaya Jammeh munafanga la nyadi le pour ka ko tamandi je membe diala ate warando memba tela ni dia nyin timmandi la
To achieve his objectives, we will be interested to know from you.
pour ka tela hamen ko nyin ka timmanda bela fila ka wol fanal long ning aytra misalo dol fanam be fanam bulu.
Thank you very much, Mr. Touré. If you're ready to begin, we will start your testimony.
Inumbaraba ke Mr. Touré silang ning aytra be pare rim pour yela sedan do nyin damuda nsada damuda.
I'm grateful indeed.
Akitanya nyaboti kendeke.
Kindly provide your full name to the commission.
Dukare toni konton fo molie ban commission ya.
My name's BORRY S. TOURAY.
Nto momenti BORRY S. TOURAY.
What is your address?
Ila address odum.
I live in Farato village.
Mbesiring Farato Sateoto.
And what is your occupation?
Amila do ko
I'm a barrister and solicitor of the Supreme Court of the Gambia.
Ndemu kiti ndirlani kiti bonyotolale ti Gambia la Supreme Court bundala, kiti bundala.
And what is the name of your chambers?
Ila do ko bunda nyinga todum.
My chambers is called Crown Chambers.
Na doku dula mfansun dinkiranye kafuje ne Crown Chambers.
And where is it situated?
Nyin ila ing office onyi mem Crown Chambers abe mindole.
It's situated in Banjul at the junction of New Primate Street and Boxbar Road.
Abe Banjulu New Primate Street ni Boxbar Road la sila kumbengoto.
Mr. Touré, you're a very experienced and senior lawyer at the bar. Can you tell us how many years post-call?
Mr. Touré ita mo molde me yalon ko yellondo soto andungi meta lawyer len kafuba nyin kono le faysa fono nyi sanji jelle tarta nyin doku wol kono.
I have 21 years post-call at the Gambian bar.
Nga sanji mwani clean ke doku la bringa dati Gambia la kiti bundala.
Kindly give us a bit of your educational background.
Silang ila londo nyi kala karango nyi ya damura nyameng afanya bang.
I did my primary schooling in Sinchu Njabo Primary School.
Ngana primary karang ke Sinchu Njabo primary karang bungoleto.
In the North Bank region.
Obekere wan tundo le kang.
Sabah Sanjal district.
Sabah Sanjal Banko kang.
I sat to the common entrance in 1982.
1982 sang kono long alundi kontiboke ikafume common entrance.
Then I proceeded to Nusrat High School.
Tata Nusrat High School.
I spent 5 years, 82, 87 in Nusrat.
Ntarta je sanjilulu kabo 82 kata 87 ngawle ke Nusrat karambungoto.
After writing to the O levels, I proceeded to St. Augustine's to do my sixth form.
Bringana O level londi kontiboke ntata St. Augustine's kata na sixth form kije.
I completed in 1989.
Ngaw bang 1989 sangokono.
I worked briefly as a teacher in Nusrat.
Nga wati sutunke karandirola Nusrat karambungoto.
For one academic year.
Sanji kilinga ole ke karandirola.
And I also worked as a field officer in the Women's Bureau in the Office of the President for a month.
Nga karkilindo ko fananke musola office bala doku bundala me yalonko. Welle kata bantala ka doku le ke dinkirato ka fana mene field office and wotu mo jebe president wala office wala koto.
Then I proceeded to Frabe College, University of Sierra Leone, a
Natana-
4-year degree program to do
Nata-
LLB.
Ntata Furabe College me alonka be Sierra Leone ntata na LLB ke wolto sanjinani.
I did my bar in 1995.
Nganna ba karango ke 1995 sankono.
That was my last exams in my life, and I failed that one.
Wala munna londi konti bo labangoti na baluwo kono bari wode manganye de mboytale.
I came down home. I got appointed in the government public service as a magistrate, first-class magistrate.
Seytana mbari nata do ko soto mansabunda la nketa magistrate fono kitindir lalti ikafome first class womu alodu la fololete.
Can you tell us what that means to be a first-class magistrate?
So fono nyama okoto munete ni ko inara na Gambia bango kanya inara na do ko soro mansakunda koto kake first class magistrate okoto munete.
The magisterial bench was divided into 3 categories. You have the professionals who would be trained lawyers or who would have had their first degree, LLB.
Ya tala dinkira sabalete o kitindir bunda folo wala nyinti men ya lonko ye karandi han fo makama take men ya lonko ye karanta fo LLB soto wolmu anola leti.
And then you have the second-class magistrates.
Ye fanna fulanyang soto ka fo men second class magistrate wala kitindir la bunda la lodu la fulanyangoti.
People who basically were retired and had a high degree of experience in the public service.
Wala moluti men ya lonko ye do ko ke bari na tay daha bari bitu ye londi saharing londi kono fa dum rim basoto do ko nyi sambola karola.
And third-class magistrates, these are ordinary lay people who can be mobilized and then appointed to handle matters.
Nda sabanjango wala molti men ya lonko manke ko ye karamba ke kalondi bal soto bari mollemu menu la ko faramansata isita yolu fanalu londi o bunda to men ya lonko isi jube oke tilingunin to nya sambola kitola karola.
And then in 1998, I went back to Sierra Leone to do my bar again for the second time.
1998 muruta Sierra Leone nyin silo katanna ba sayin kanke kote ke sinya fulanjang.
Mr. Toure, before you move on to Sierra Leone, I just wanted you to give us the difference between the roles of the first class, second class, and third class magistrates.
Mr. Toure, jande be ta ka kuma fonye ila murunga sinya fulanya kata Sierra Leone lafta ka ya fonye wala mun fatam fansile be nyim first class, second class, third class magistrate muna be tema.
When you are a first-class magistrate, you can exercise all the powers vested in the magisterial court system.
Ni mu first class wala makama folo nyinti woto sembe wo sembe nabe wo kiti bundala istesi o tamandinole ila do ko nyin sambola karola.
And in terms of the differences in their civil jurisdiction, first-class magistrates can handle matters to the tune of $1 million, claims up to the tune of $1 million.
Between first class magistrate palastiolu fanalu kitolu lanya anin kolu kafutema nyaming isi kitolu tano le anin kubonyoto me ya lonko nin dépense bakono wala kodi kubakono men sita hanfo dalasi million killing itelisio wo sartolu tano le.
Second class, up to a tune of $750,000.
Second class wala mlu la flanja wonyenti wolu isi menu tano ning misali kama kodi ko bakono men sita hanfo dalasi wuli tawro wala nyong.
And third class, up to a tune of $500,000.
Unda sabanjango nying wala menu ya lonko isi kuta mandino ning kodo la karolem men sita hanfo dalasi wuli tallu nyong.
And I must also add that in the whole of the Commonwealth, the jurisdiction of the magistrates, magistrate courts in the Gambia is the widest in the entire Commonwealth.
Commonwealth tundo mume obekang kolu lanya nte la Gambia tale kono fanuta bunda dolu da taluti men ya lonko bebe Commonwealth koto.
Especially in terms of the exercise of criminal jurisdiction.
Sako kolu menu tilinta kruya kolu bonyoto la ninga kitolu tamando.
Magistrates in this country can hear capital offenses.
Magistrate olu menu be nyimbanko kang isi kitindiru kunton kolu beta nole men ya lonko wolem kukurungulu kunton koti.
And Mr. Toure, that would be the first-class magistrates in particular.
First-class magistrates.
Yes. First-class magistrates.
Ha, wolem first-class magistrate woliti meno be lodula follow nyinto.
Because they had the power and the jurisdiction to hear more complex and serious matters than the second and third class.
Adu itole sembo sodale andu loi sembo silo dilale pour ka kesi falta men yalon ko koleya tale.
Ha, abe onyale.
But just to be clear, during the time that you were appointed as a first-class magistrate, you still had not sat to the bar.
But hani kabi purja yesene yadron kabri yete tombon keke first class magistrate hani kabi email back follow.
I did my bar in 1995.
Nanna back in 1995 sangole kono.
It was because of me failing my exams in 1995. Why? I had to come home to work on the bench in order to prepare myself for the second session, for the second sitting of the bar.
Ngawo ba londi konti bo flo menke wairi mboytele manganye ngwakilta seita nang nata benchot wala na kitindirla la si lolula puru nyin kamala ngam fam parendi kotake puru nyaton ton sina akono masata.
And I must also...
Sorry, Mr. Touré, for interrupting you. I just wanted to bring out the point that at that time, there was no requirement for you to sit to the bar as it is the case now.
Yes, you are perfectly right.
Council kay watembo amanke nyimukuti men kaninta puruka kulu tamandi mensike londi konti bakaro la kosa inga benyami fatatale.
Kindly continue. My apologies for interrupting.
I'm grateful. Then like I indicated, I did my bar in 1990. I went for my bar second time in 1998.
Between nata muru katana ba nyin no masata memwa sinya flanjanguti 1998 sangokono.
We were interrupted by the events in Sierra Leone because of the civil war.
Between kolu nata na karango elandi ka kuntu katu tumo damma kelo wulita Sierra Leone banko kang.
However, we completed the course, and in 2000, I was enrolled at the Gambian bar.
Baro nyawnyandi nga katangan na karango to labang bitung hanfon seitana natana dung Gambia ba kitindir bundala.
And
2000 sangokono.
I still continued service on the bench.
Bitung hanim bin continue ta do ko la bundala ka fudami ye bench wala menumu kitindir la silalu tije.
And over the period, I had a couple of training on human rights because I was a member of Amnesty International.
Bitu wo wuce okono nata karan londi karan fason fula soto me ya lonko aben adenta hadamaya nyanta kunya lela katu wotu mombe kafo kono kafo me Amnesty International.
Gender was also part of my training.
Musuninke tema fatam fansolu fanaluda benna karango konole.
We also did a course in Sharia.
Andu londi karango fananke Sharia kitindir kunyal tole.
That's my professional and academic background.
Wala mo na londo silolu ni makamo luti ngamen soto karango ni londo la karola.
In terms of your experience as a private legal practitioner, where would you say your expertise lies, or what kind of cases would you normally involve yourself with?
Let me also say this, all baristas in this country are general practitioners.
Baranganyim falamfo makamo me kafaye barista meni ya lonko be makamo to nyimbanko kan wolube mu ateo kitindirla kilingol leti.
There is no one particular chamber that specializes in any one aspect of the law in this country.
Amunta bunda lori ntije ka foko nyim bunda kari nyim woluka bula nyi londi kar le noma wala woluka nyi londi kar le kitindi wo bunda lu mansoto.
That's due mainly to the nature of the economy, small size of the population. But my practice over the years got concentrated on criminal and civil matters, more especially land.
Ujama katilim banko fanko Kenya lela aning banko la doya Kenya fanan kama. Bari bitu ntela kulu noma sato nkabula menu noma bake wala mnying kruya quality meni alonko ikake ikana ifinti ke ifutandi kiti bundala.
Taking your career in chronological order, you started off as a magistrate, first class.
Nia jube la londo nyi ila nyati li nyanyi kelenya purunga bulanyo noma nyati tilinda nyoye nyame ya follow damendo wala kiti ndirlati kafme magistrate.
Yes, that's true.
I would like us to explore the order of judicial interference.
Mbela fla purunga order for senade domande wala kiti bunda nyi na by
the executive into your work as a magistrate. After you were first appointed as a magistrate, where were you posted to?
Briye tombon kuta ke kitindir la duma lankori ga ba fala me magistrate ye samba do ko la min dole.
I was posted in Banjul Magistrates Court.
Mbe Banjul Magistrate Court le nga follow jele.
At that time, who was the Chief Justice?
Wato la jumalam kitindir la be la nyaton koti.
The late Chief Justice Omar Al-Ghali.
Chief Justice Omar Al-Ghali.
He was a Sierra Leonean by nationality.
Atemu Sierra Leone banku dingoleti.
May I apologize? Chief Justice Omotion.
Chief Justice Omotion.
Omotion was a Nigerian.
Omotion mu Nigerian oleti.
Came here on technical assistance.
Natajang nyinkam mapurae makoiro tamandi doku wala karon.
Al-Ghali came after him.
Al-Ghali bulata atelenoma.
Okay, but generally on the question of interference, may I divide the Jammeh era into two phases?
Niya jube mansala dabulo kito nin kitindir kuoluto mbela fla katala ka ke fanna fulati.
Mr. Touré, before we just go there, I just wanted to know some of the key players in the system, like who the DPP was and who your principal magistrate at Banjul was, just so that we can get that context and background before we move on.
Much obliged. Principal.
Jannim bida wodo fala mbela fla kalon folo jumal le mu molti men yalon ko wolle fam fam woda ba ko nyin kono misal fe mbela fla kalon jumal principal magistrate jumal mun DPP di men yalon ko wala katara marling masakunda la kitindir la nyaton ko la o sifala na nyongol mbela fla ka wolle lon folo jannim bida wodo.
The principal magistrate in Banjul Magistrates Court was His Worship Magistrate Onya.
His Worship Magistrate Onya wole mu kunton kotinu wo kitindirla silolu la karola.
He is a Nigerian by nationality and a man of distinguished birth and a very strong character.
Ate mu Nigeria banku dinguleti mole fana mu me yalon ko atobota adu molem me yalon ko ala kolu ake bambandi bakele naba atamandila.
Was he also here on technical assistance?
Yes, he was. He came along with three of his colleagues. Magistrate Sadiq in Kanifing, he was the principal magistrate, and Inyang was in Basse. He was also a principal magistrate. They are all Nigerians.
Magistrate Sadiq member in Kanifing, and Magistrate Onyang wobenum Basse, bari telube na ta osilakili mole kan kitindro la karola banko kanjang.
At the material time, I believe it was the Attorney General was Mr. Marong.
Andu otembo nlata la ko tumo Attorney General moleti kafome Mr. Marong.
I'm not very sure about that, but I have a feeling that it was Mustafa Marong.
Amang ko imma baba bakere bari ngani miro soto ko tumo membi je kafa ne Mustafa Marong.
This material time is what year?
It was 1995.
1995 sangole konote.
Yes.
I believe Mr. Fafambai was the first Attorney General.
Njikita Mr. Fafambai atela munu Attorney General.
Yes, that's right.
Umuto nyalti.
Masakunda falengo kera waro men.
Umuto nyalti.
So was this after he had been removed?
I believe so. I didn't meet Mr. Mbai in the office.
Mr. Mbai tara office.
Kindly tell us what your experience was at the Banjul Magistrates Court, working as a magistrate under Principal Magistrate Onya.
Silang afanya bang wato mena ita mukiti ndirla ti me alon ko bedu ko ke kam principal magistrate Onya koto. Muna ketete la kulti men yalon ko yolel karanga ko nyi do ko nyi kono je.
Okay, let me go back to the two phases of division that I would categorize the Jammeh administration into.
Ngata nga ofana fulo memfo alhakatu ko nga Jammeh la mararo wucheo kolu talanya mengake ofana fulo mende barnga muruje kan.
Yes, it's true. There was interference with the judiciary
during
the pure military era, that is during the transition of 2 years.
Wotumo sojar mararobe kering wuche falingo beke kantumo men wosanji fulo kono.
But it was far less in degree than what later came to pervade after he had transformed himself into civilian administration.
Bari wotumo akuo mansia asembo fana mawara baba bake ko anata laban nyaming biring ay sojari abula ay faling anata ke civilian oti anata dum mararo kono wotembole mkulu wajabita.
The government, the executive then had very little interference with ordinary civil matters or ordinary criminal cases.
Wotembo ko fulodulato wotumo kunton konying ala ma kango doyata bakele kuolu to men keta okuruya kuolu bonyototi aning moni motema kitolu fanalu lanyato.
Their focus mainly was on matters involving senior security and police personnel. Senior security, army, and police personnel who were arrested and detained, and some of whom were being prosecuted.
Wotembo itelanya tilinya tilinta kuomena wala mbrim falingu keta ye police kebalu menu muta ni sojar kebalu wala kanto ni tankada bunda nyaton ko menu ye muta be dolu kitindi kan wotumo itelanya tilinya keta wolela koltinu wotumo.
So my first experience in terms of interference was when the case of Inspector General of Police versus Pasala Jain, Ibrahim Chongan, and Keba Diba was assigned to my office.
Amunta ntela londi follow kuolu tamandi nyato dabulo la karola kitoto waketa watu ulti bring kito futatama Inspector General of Police Pasala Jain ani Ibrahim Chongan briwo lakko nata kafutama
and Keba Diba.
And Mr. Touré, just to give us some background before we go into that particular case, give us the context, especially with the passing of some of the military decrees at that time, what the effect of those decrees were on the laws of this country, especially the Constitution, before we go into the facts of that particular case.
Bunda lua bundi government decree mo decree nying anata na mun kole akule sabu ko nying kono janni be constitution nying londila.
When the Armed Forces Provisional Ruling Council was being created,
Biribe AFPRC lawo council bunda londila Armed Forces Provisional Ruling Council,
they promulgated Decree Number 1.
Certifolo dada ikafome degree number 1,
and that is the Armed Forces Provisional Ruling Council Establishment Decree.
Wolem sarto timmeye Armed Forces Provisional Ruling Council la sarto wole bunda fangolondi.
Sorry, may I apologize. The first decree was the Constitution of the Republic of the Gambia Suspension and Modification Decree Number 1.
Al haketu filo ketaje decree follow nying wole mi banko la sambaran sarti bukuba nyin ne fongola kolu follow falling we ka fole constitutional aning itele lafta kolu menu tamandi la je.
By this decree they suspended the whole of Chapter 4.
Bitu decree ya sama ayasabu constitutional la sapanani njangu mumeo be Chapter 4 yo be denne.
And this is where you have the entrenched and protected rights conferred by the Constitution, fundamental human rights.
Adum wole mu bundati meye hadamaya nyantolu be londi ke bambandi meya lonko wole ka hadama dingulu kanta ila baluwo kono amunta italio bunda nyi mumeo bele demfolo.
So the junta gave itself power to arrest, detain anybody for any length of time.
Junta nyi ngolem sojar marabunda ye sembo di ifangolula iteli lafita momondi marala wala lafita momondi mutala isi muta ye sindi fojanning wati mendiate tole nyawnyandi nyama.
And also they arrogated to themselves the whole of corpus of the executive and the legislative power of the nation.
Bankola sembo kabirim mararo la karola fokuntonko fanan sembo la karola anin kata kito fanalu lanya bunda tukumu la karola yo sembo bechika ya di fangulula.
And Mr. Touré, sorry, just so that we can understand before we move on. So all of those protective safeguards that were in place during the criminal justice system for accused persons were no longer available to them at this time.
Amunta pour mo tumiri mo o mea lonko tumiri mo lam pour ka même loi men nyanna ka tankandi ka tankandi olbe mu kulel mea lonko olbe man raw tumiri mo ko tanke olbe bondi jele ko.
Yes, that is right. You can no longer as a lawyer go to court and then file an application for the release of your client who perhaps has been arrested and detained.
How muto nyalti ni mu lawyer ati wotembo fango ititano la kiti bundala pour kata safero kije pour nimmo mutari ngo bije mem muitela kiliano ti pour isio bula nyaming wotembo lawyer ma sembo soto.
The stage was set for imposition of dictatorship from the very beginning.
Amunta wotumo lem yelondiro ke kasulo dundi sartolula me ya lonko wolle be tajreya aning sembela mararo londi la nyimbanko kan.
So there was no right to liberty per se, the right to bail and the 72-hour time limit
Amunta
was also not applicable.
Wala mnyinti ko hanama de moma nyanto soro fay puru ka fansoro andung puru bel fanang na karola fanana na kolea ko kono.
That's absolutely right. All notions of rights and freedoms were suspended.
Umuto nyalte bitu molla taram fambulo fansambo aning ila kolu Kenya mfayo yolu be kafunyo male utumo ye deng asembo te mola.
And what did that what effects did that have on the rights of accused persons, especially if you try to juxtapose that with the case of IGP and Pasala Jeng and others?
Wona na mun kolea kulle sabu tumiri molla misal fe surtout ni nata na sawndi yana misalo di IGP Pasala Jeng anado nyol la case nyinto.
May I give a bit of a background history here?
Please go ahead.
Before the case file was assigned to me, there was a lot of battle between the defense team and the prosecution team for the bail of the accused persons.
Janning kito fongo be dilantela nyo sababale tartaje nung kitindir lalu aning loya do lutema menu be lori nyi muta moliye akete mo nyo sabale tinung karaning karatema janning kito nyimbe chikala kadintela.
And the trial magistrate Onya, who had conduct of the matter, ruled in favor of the prosecution, denying the accused persons right to bail.
Magistrate Onya me ya lonko ko be lari ngatele bulu nung ay nyi sembo tamandi je kabalang puruka nyi molu bail menu be loyal membe lori nyi moli nung amunta ayolu korindi jele amansong puru nyi molu hanikili ye bail ikono.
And was that pursuant to decree number 1?
No, that was not pursuant to decree number 1, but other follow-up decrees.
Wo amanke ko abe dendin decree follow nyin la de bari bitung decree dolu fanalu nata fintile men ya lonko wolio dinkira bambandi.
In particular,
sako membe ko
you have state security detention of armed and police personnel decree 1994. That's decree number 3.
Sako sarti sabanja umeng inata afintindi 1994 men tilinta molu mutola menube kantonin tankada bunda dokola wolem police men ko menube security wala karola.
And I believe this particular decree affected these particular accused persons because they were military personnel.
Rasa munta mfele ko nyin decree ni kay men decree men nakmo foten anarna nyin tumi mol nyin batandi bakale me alonko tanko bunda molla.
And their names were specifically, I believe, gazetted in the decree.
Andu itol nyi natene tol nyi kusonson leila in gazeto nyin to ka korosi.
That's quite right. Pasala was from the armed forces. He was later appointed as Inspector General of Police.
Umuto nyalti Pasala atebota kanto nintankada bundale la dunkokola ina atake Inspector General ti Police la
Ibrahim Changan was a Gendarmerie officer and Keba Diba as well.
Ibrahim Changan atanin Keba Diba itulbebe zandam bundale la nundokola utumo.
They were later transferred to the police when the Gendarmerie was being dismantled.
Ina tesa undi kenaiti police bring ibe
so legally speaking, Magistrate Onya was right on the law as it was.
Magistrate Onya
in refusing to grant them bail. There was an application before the then Supreme Court, which is now the High Court, for bail.
The Supreme Court member High Court bail
and the Supreme Court also upheld the position of the magistrate that he doesn't have jurisdiction to grant bail.
Adu bitungo kitibunda santonko nata nyi londi magistrate la okangokang ko aman sembo soto puruka bail di nyi molula.
So it was after all that skirmishes and after the transfer of Magistrate Onya from Banjul Magistrates Court to Kanifi Magistrates Court.
And we nata Magistrate Onya saundi kabundi Banjul Magistrate Court kasamba Kanifi Magistrates Court.
Because the state had intractable difficulty in getting decisions from his court going in their favor.
Puruka kangulu soto atela kiti bundala kangulu meni ya lonko wole mansa nyatonko mansa kunda fasa nungotumo.
They had to re-engage one lady by the name of Mrs. Scott, wife of former Liberian ambassador to the Gambia.
Inatamola makwero nyining Mrs. Scott meya lonko inatate dundikolo kono andu otumo Liberia bankola ambassador membe nyimbanko kangole la musomu o marioti.
Mrs. Scott came here on technical assistance as a magistrate from Nigeria, and her maiden name was Miss Ogojafo.
Anatanu jam doko silo melna wolem kana makwero ke wodoko bundala bari abinatu mo melna utumo to men ka foye ka fole Ogojafo.
At the end of her term, she decided to stay on contract.
Bari birala doko keta hanfo awucheo banta nyinata dunga fango kono prasi tujang ay continue doko la bari wo katarta contract ko le kono.
Along the line, she got married to the Liberian ambassador.
Bitungo wucheo kono lem anata futu Liberia la ambassador e membe Gambia jangutumo.
And the Bar Association petitioned the executive that you cannot be a spouse of a head of mission designated to the country in question, and you be allowed to function in the public service of that country.
Bitum bana ta nyin safero ke ko te kenola ite kenola no monyoti moye me ya lonko mu ambassador le tinyim bankun kan wokola ite me mo mari la no monyoti yena o silo soto ka o maka mota pour ka do ku façon ke banko kan iko te kenola.
At that point, can you remember who the president of the bar was?
I
did not join the legal system then. I was in the university.
Wotumo mantara lua bunda do kola otembode mbe university oltonu wotumo.
But it must have been between Surahata Jane and Hussein ONM Dabo.
Otembo abetarla mo fulale tema Surahata Jane wala Hussein ONM Dabo.
So following this petition, Mrs. Scott was obliged to resign her position as magistrate.
Birinkiti bunda yo kanindiro ke yo safaro ke bitu Mrs. Scott fere mantuwa je faye dahadu ko nyinna.
The Liberian ambassador became the dean of the diplomatic corps, and because of that, she had close personal interaction with the former First Lady Tutifal.
Tumo Liberia la ambassador le nata ke ambassador dolu bela kunton koti Bangkokan ikafole dean bitu kamala ala onomonyo anim banko president la nomonyo la kulu nata katanyo la foi futata nyoma wotembo Madame Tutifal jamme wala be futu wala president.
I must also add that Mrs. Scott was a very highly vindictive person. She had a lot of difficulties with members of the private bar.
Mbenyim fanan la fala je ko Mrs. Scott wotembo mole me alonko bitung nyin kuolu ka kuolu noma sata julujo kan wakadia num bake andu wale ya sabu aning kitindirla jamali kole ya kuosoto meni alonko ibe banyi na karola utumo.
So she got Tutifal to convince Jammeh that if she was reappointed as a magistrate on the bench, there would be difference in Banjul Magistrates Court. The state was going to get convictions in its favor.
Bari anata kata ay fero ke hanufo ay ngani oning hammo dundi akafunyo kono memu president la musoti wotumo Madame Tutifal Jammeh pour wo sidia mu akemae nyin kanko ni ate murundi na wo kiti bundala mansa kunda ka kole ya kolu menu soto nung e wo kito la karola puruka ite langani ya kangolu tamandi akobe bolale ibe amunta mansaba ngani yo soto na le kiti bundala utumo wala Banjul Magistrate Court kiti bundala.
So the junta reappointed her as principal magistrate.
Bitung sojar bunda na tasa inkanta aketa magistrate kunton koti principal magistrate
and forcibly transferred Onya from Banjul to Kanifing, and she was to take charge over all the sensitive case files that Onya was handling at the material time.
Bitu watembo enata Onya force to saundi kabondi Banjul kasamba Kanifing kiti bundala bitung ate meng ate ogojafo me ya nati je bitung silango tumole ngabulona ata la failo luning kito lukang meni alonko magistrate Onya be wolle tamandi kanum bitung ate nata si wolle kunna.
And would you agree, Mr. Touré, that that political appointment was a direct interference in the judicial system?
Certainly it was. It was.
Political karola ke dabula kiti bundal no mukula me alonko bantambil bukatra wotonu o wato wala no
ha wo mu ko le wo mu bantambilo le fangoti ka o katenati ka adundina nkiti
It was clearly a violation of the Geneva Convention on Diplomatic Privileges and Immunities.
adu wo fango ay sarta dole tinya sarto me yalon ko dunia be kambenta wole la bunda bala ye mellondi nun Geneva Switzerland banko kay ka foleye Geneva Conventions nyin sarto be lorin woleto bari amunta itellate tombongo woyo sarto tinyale.
So when she came, there were so many files.
Mr. Touré, I just wanted us to just go a little bit back and tell us what the source of this information was, the information about how she became politically appointed.
Mr. Touré selenga murko ma domanding ta fanya bang nyin kibaro nyin aketa nyaadi le akeno ra nyaadi le fo inara na nyinta ya murundi do ko la politiko la karola politiko silo men da fo ya murundi dan kana do ko la kotake ka ke magistrate woti.
At that time, I was not very much connected to the establishment. But Magistrate Onya, who was with me in Banjul Magistrates Court as the principal,
bari Magistrate Onya ni membe nyobala nung Banjul Magistrate Court ko atemukitindila nyaton koleti
had a very close relationship with the Nigeria High Commission and with the Ministry of Justice.
Ay chokinyola sutunne soto anin Nigeria la High Commission tema anin Banjul anin minto
the Attorney General's chambers.
Attorney General la office onying.
So news that Mrs. Ogojafo was going to be appointed as a magistrate
Kafoko kibaro me yaitaniko Mrs. Ogojafo ba tombona le kake magistrate
reached us well in advance of government taking a decision on that.
Wo futatan teluma juna le hani jannim man sakunda ba fang akonyin kela.
And how it was all generated, we also got the information.
Atamata nyameng akolu lata nyameng ngawo kibaro lu besoto otumole hani jannabe kela.
Yes.
Thank you very much for that explanation. Kindly proceed.
So she then became seized of all these files, and then for some personal reasons, and that's by virtue of some relationship between herself and the former Inspector General of Police, Pasala Jang.
Bitung anatake moti memmarata o failo lubela anin kolu meni alonka yetaraje bar bitum fanan kolu lanya anatake nyintiko anin mola kolu takita nyola me alonko wala kita moti ka fa me num Pasala Jang,
who was accused number 1 in this particular case.
Me alonka telo motu mirim folote nyinkito kono.
She had moral difficulty handling that file in particular.
Wo keta e kole akote afango sondo mo miro la karola purka o failo tamandi.
And that was how the file was assigned to me to deal with it.
Wo nyale asabu ye failo nyinchika inata dintela purunte ngatamandi.
But the government itself at the time was not aware of that decision.
Bari wotembo mansakunda fango mambo wo kango kalama ubetala tumomeng.
So when I was assigned the file, I went through it, I came to discover that there were 52 adjournments on record.
Biringa failo nyinta ndunta kono ngala kulu kesemeti. Ntata tarako sinya talulu nimfula ikakitwa nyimama ndika deng.
And on all those occasions, it was only on one day that a real trial started. That was when PW1, the first prosecution witness, was invited to commence his testimony.
Aduwo kita o sinya talulu nimfulo beka kito deng. Sinya kilinnamu ye konyin kito fango diamu andu wolungulemu lunti meya lonko sede folonyin nata finti kadiamu akonyin kono.
And what was the reason for all the other 51 adjournments?
Sa mo nan dalilo bakang ka sabu meya sabu fo nyin lung talul ning fulo be ka lungol sounding fa furata fo mo nan dalilo di.
There were many factors. One was applications relating to bail, adjournments, arguments. That was part of it.
Kujamale bedendingala bari bitum bel kuolu kitola dengo Kenya lo anindia mulu membe dendingala wulu bebe akonyin kono le wutumo.
But nothing of substance happened.
Nothing of substance.
Para manke kukumati.
So I then issued notices and gave a date for matter to be mentioned in court.
Bitungo tumole nata molu kalamutandiroke aninga kango difanang lumeng akobe fola kitibunda nyina.
Notices were served on both sides.
Nga kalamutandiro samba karafulo lubela.
And then we converged and we took a fixed hearing date.
Mbenta bitotumole nata kambenga lumuta lumembe kala akuo lungo diamoti.
Now, on this day in question, the state did not produce a witness.
Bitungo lungumenga taonya lumeng komba akuo diamula bitum sakunda mandan sede fintindi membe lola akuo kono.
Can you tell us who the prosecutor in that case was?
He was
Lamin AMS Jobate. He was then the Assistant Superintendent of Police in charge of prosecutions.
Wotumo Lamin Jobate lemu kitindirlati wotumo atelefona mu Assistant Superintendent Police la Karola amunta akonyen dunta ateleblo kono wotumo.
Is this the same Lamin Jobate that appeared here on the TRRC, previous Minister of Justice?
Yes. He was a lawyer who was on secondment in the police force, and he was in charge of all prosecution matters.
Atelemu loyati yemenna do ko samba police la Karola ndum kitindirolu be nyan natata atele la Karola.
So when we converged to hear the matter, the state did not produce a witness.
Brimbenta purka ko wonyin diamu mansa kunda manna sede fintindi.
And we asked him what was the reason why they were not proceeding with the matter.
Nga nyinin ka muna na itelu mantara tenten kan ko nyinna.
And we were not satisfied with the reasons that were advanced.
Adu itel nata dalilo lu menu fontele wolu manke dalilati meyentel nyafa.
Because majority of the witnesses were police officers working within the establishment.
Kadu mo jama membe itel law sedo lu kono menu fo wolu be mo police leti menu be do ko la bunda nyim fangoto.
And most of them were, in fact, at the material time at the police headquarters in Banjul.
Adu tembo fango wolu jama bebe kono ibebe do ko la banyunu police korda ba nyim fangole to otumo.
So it was like taking the court to ransom. Because
there was no justifiable excuse.
There was no justifiable reason. My personal impression was that because the case has continuously been adjourned, so that trend was going to continue. That was the prosecution's attitude.
So what position did you take at that point?
The defense lawyers made an application for me to dismiss the case. And I can remember there were Miss Drame, Usman Silla, and the late Pap Chasen Seka.
And by Miss Drame, you refer to Ida Drame?
Yes.
Miss Drame, Madam Ida Drame.
So by the time Mr. Jobati realized that something momentous was taking place in court, it was almost late.
Mr. Jobati binajela kohe kukuma bale pareta kela kiti bundala baru utumu atela karola tardeta lede.
So they thought I was going to adjourn the matter again for ruling. I insisted that I was going to deliver the ruling the same day.
Itele mutanunko mbe lundo le mutala kota ke lumme mbe kito nyintela. Bari mfana lota nyine kanko ulungu fangole mtebe kito nyinkela kate.
So I went into my chambers whilst I was writing my ruling.
Ntata na ofiso kono mbenna kangolu safe kango tumo mbe kango mentala.
A whole truckload of soldiers were deployed in Banjul Magistrates Court.
Ye moto fa mumeole nati je wulunga bemu soja rolti ye nati Banjul Magistrate Court.
It was like a military camp.
Amunda wolunje bele ko sojar campo.
Some of them, in fact, entered right inside the courtroom under the roof of the court.
Jama fang soton ta menu dunta nan kiti bunda fang nyin kono.
And were they armed?
They were all armed. All of them were armed. They were not, in fact, with riot gear. They came heavily armed.
Misal kama ningere wala keta wala balambaya ke fankanta jona wala mena ni wala manna itel ning kidol le nata
when they came combat ready.
Inatale ko molu menu pareta kelo.
Yes, it's like if you are deploying them to the battlefield.
Amonda inatale ko menu pareta tala kele wulo kono.
So when I entered the courtroom with my ruling, I asked all the soldiers to go out.
Bitunta nata dum kiti bundala ninna o sartolu menu ngesa fe nko sojarolu be finti banta.
they had no choice. They had to leave the courtroom.
Imam fere do soto de findita kiti bundala.
And I must also add that these three gentlemen went through a great deal of trauma.
Mbenyim fanam fala ko nyimmo sabolu idunta ku kole mballe kono.
Because I observed for long when they used to escort them to court.
Kadunga korosi wati jang wato men ike dandan nan kenati kiti bundala.
Under the roof of the court.
Kiti bunda nyim fango kono, bungo fango kono.
Wherever they are seated, the soldiers will be standing, pointing the nozzle of the gun against each one of them.
Kato hanni nyimmolu be sirin dawoda. Sojarol kai baindi nan ka loy ikunto kiti bundala andonga bukadang lo kunto la de. Eka kidole fango datili nyimmolu lay be sirin dame.
But when the matter was assigned to me, that was the first thing I said I wasn't going to countenance.
Mr.
Touré, that position taken by the military or by the government in sending armed soldiers to the court was, in effect, an attempt to intimidate you.
Woto Mr. Touré o masa kunda warando sojaro kundaro yo baro menketeng puru inaje ka sojaro kinanje nin kidoldu ina kidi bundaro o mu kula de me yalon ko inata la puru kete fananke silandi.
Yes, that was part of it, but also there was a security aspect of it because they were afraid that I was going to release them on that day.
Woda bijele de bari kanto la karado fananda bije wala mindi ko sobeta ko asikeno ntenga nyimolu bula wolum fango ke bula ye fansoto.
And members of the family who were there too were prepared. If I was to discharge them, certainly there was going to be a big showdown between them and the security. People were just fed up.
Nyimolu fanal la badingolu bije ila dimbaya lu bije andu wolum ibe pareri ngol fanal be pareri nyina la ni yebula abe kelama mambale tinunje wolum katwotumo molu fasita ifasita ko la ferengotumo.
Were you intimidated?
Yes, ilandila baita fankunda.
Far from it.
Ajamfata wala.
I drove them out of the courtroom and then I proceeded to deliver my ruling.
Mr.
Touré, I'm very interested to know why you were not intimidating under such circumstances. I think any reasonable person would have been. Can you tell us from where you drew such courage and boldness?
Well,
Mr. Touré afanyeng muna keta dalilo tinung meye tejuso bambandi aye hanyindi puru ka okota mandi wonyama wolun katu ni momondi ndolu abekele kijate ole tifangi silang wo molu wo joranti olula na aje kama.
I think it's mainly because of my nature.
Ngamira follow ndanya wole muku followti nsiofo.
I hail from a very difficult father. It's not somebody anybody can easily intimidate.
Nde fama mu moleti me yalon ko ke kolembale mu adum purka silandi wo mu kuleti me yalon ko bukana mama ndifang mo buka silandi no.
And I remember the day I was appointed, I came home with my appointment letter. I showed him.
Lummen hakilo baka yen tombon kanyindo ko dinna mbese la suwo kono tumo menna ninna letaro nata nyola le tembondir letaro me ya dinna nata mfutatama.
He asked me to sit down.
Akonyen nsita.
Said, this your work is different from every other type of work in the public service.
Akonye tela nyindo ko nindo ku dolu be fatata le mansa kunda do ko bundala.
Told me, he said, for every case you preside over here,
akonye isita kiti wo kiti kunna jang.
God the Almighty is going to preside over the same case to account for the righteousness or otherwise of your decisions hereafter.
Sinyilonko mansatalla Allah subhanahu wa ta'ala itebe kito tamandila nyaming ate mansatalla fanambe ebo kito tamandila wole nyama woto isi haklotu tukunguluto nibe kito nyinkela.
So he told me, don't ever be afraid of anybody in the system. Do what is right.
Akonye woto kanasila mo womondina nyin bundala nyin doku bundala karola mentilinta bulawo no madron yeto nya tamandi.
But quite apart from that also, I was in Sierra Leone and I've seen war from another dimension.
Adung hana manke o dammanti mbenun Sierra Leone nyinkelo damu tata nyala jele mga kelo sede ya nyayaje kelo fanang na kulu koleata nyaming.
It's much more difficult to deal with the police than to deal with the army if only you understand their psychology.
Koleata puru inin poliso liye kudu nyotema wala koleata inin sojaro liye kudu nyotema natara ye la kolu tanya ning ila kolu lanya fanan koto long.
So I delivered my ruling, and then I made an order that the accused persons be remanded in custody, because that was an earlier decision by a previous magistrate, and the High Court has affirmed that. I couldn't overturn the decision of the High Court as far as their release was concerned.
Baribiringa kuota nganying kele koye bula baribitung ibe tulam remand le follow ko kiti bunda menu follow tante nyaje ko liya sarto landi nyaming yo adumu bunda le tentete men na kango bondi nola wala kela kango bayno wala nante fana ya landi wonya ko ituliya landi no nyaming.
What was your ruling?
I dismissed the case and then made an order for the accused persons to be remanded, because at that time they were security detainees under the decrees that they have enacted and the detention orders.
Watembo undanga na kito Kenya mendoro nga kito nyimbaile nga baile andum baribitu nata fo ye sambari man katu otumo kanto nintankada bunda la mutamolle muiti ibeolle la karola otumo.
But Mr. Touré, once that case was dismissed, in effect, there was no reason for their detention.
Mr. Touré, case ni case by dalila taje kota ke purka umare ni ka kango di purkete mura kota ke sindilu agile.
No, legally, ugly as it was, there was a basis for their further detention. Under the dispensation that was prevailing at the time.
Nielua nyina lanya jube wutumo sartolu bekeri no nyaming fereti je foyo kangota puriye sambari man wo mukolu lanya leti wo jamano.
Because these three gentlemen were already detained under the security, the decree number 3, the state security detention of armed and police personnel decree.
Wotumo sarto la bunda sabanja ome itelia londi decree number 3 itelubeole la muto kono nung meya lonko wenyin kangoli di kabrim police fo sojarolu mutamolu men ya lonko e be mutalawulu kono wol betar la sarto le kono nung.
I don't necessarily agree with the contents of the decree as it was.
Ndefango de mansong decree nyin kolu menu ba kono mansong ila meta.
And I also do not share the opinion that I do not have power to release them. In later cases, people were arrested under the same law, and their names were published under detention orders, and I went ahead to grant them bail. My only difficulty was a procedural one. The issue came before the court, and it was determined. There was an appeal against it, and the High Court affirmed the decision of the lower court. If that procedure had not been followed, I was definitely going to release them.
Amunta kolu belari no nyame wala mnyinti ko itelaw kito ko la kitido lu menu nata men ya lonka kita façon nyongol leti wo molu ninge la ko bo nyoto nte ke bulale yo bari wo tembo telako men wayri atelum kufolo nyinti wo tumo etelbe kantoni wo tankada bunda la kango men koto wala na mebula bari akola kiti kotangolu menu nata je anyongolu ninga wolu kito lu kente ke bulale.
And what decision had the magistrate court made that the High Court had affirmed?
Kanjum de magistrate court molan kiti bundan no mu kanjum alata me yalonko kiti bumba fana bulata o sar kankile wala no.
The magistrate court has declined jurisdiction on the basis of the fact that they were arrested and detained under decree number 3, and their names were published as persons who were a security threat to the nation, and because of that the court declined jurisdiction to say that they cannot be granted bail. And that was the decision that was affirmed by the High Court, that they could not be released under any circumstance.
Kitibunda ba nyang High Court ya kangomen londi ya kitibunda duma nkola kangomen londi wala nyintiko nyimolu decree number 3 imutata o kangole koto andu wala nyintiko molu memme mutata o kango koto itebula nola yo bitungo dalilo le ya sabu birintel fananga ko nyimma ntata nga jibe ko wayri wo sarto le be lori telio le londi wala decree number 3 so dalilo le ya sabu imebula no ko lata wala nyama.
So as a lower court, you could not substantially overturn the decision of a superior court?
That was the only reason I couldn't overturn the decision of the High Court. But if the matter had not gone before the High Court, and if it was not an issue that was argued and determined by the trial magistrate, I was definitely going to release them.
Ko nyimbe ole nyama Katu niaje kiti bunda sonta kiti bunda ndingula kangola amunta kolu lanya le asabu barnatara amanke woti nung tombi ntebe ngela kito kenu nyamin tombi mbe bulalale bar wotumo kiti bunda do nyim fongola kangolandi ko nyanta tamala wole yo sabu.
I would like to pose a question for academic debate. The decrees that were passed.
Bela fa nyininkala puru nyininkaro jabi. Yenyi decree men ya blondi.
They were ordinary legislation at the time.
Oh, watola luwa lo ngolo bekeri ne watola.
Come again?
The decrees that were passed was ordinary legislation. It was ordinary law. They were below the constitution.
Nimu luwa let men ya lon ko be luwa bias du malal.
They did not have constitutional force.
I know
that the decrees are now part of the constitution. But at that time they were not. Was it constitutional that they were used to suspend provisions of the constitution at that time? Could they have been legally challenged?
I don't think they could have been legally challenged at that time because the only forum where such a challenge could have been raised would have been in the Supreme Court. If I mean the Supreme Court, I mean the last and the third tier.
Ninko Supreme Court wole bunda labango me ya lonko bunda sabanjanguti kitola karola.
Let me clarify this. We used to have a Supreme Court, but it was just by name. That Supreme Court was the High Court.
Nkafale nun Supreme Court bari tole mudrong wo kiti bunda wole High Court kiti sandong.
We had the Supreme Court and the Court of Appeal.
Na Supreme Court soto bari nga kiti sankam bunda fanan soto Court of Appeal.
The Gambia's last court then was the Privy Council.
Gambia la kiti bunda labango wo tembo kafujele Privy Council.
The only place where that issue could have been ventilated would have been perhaps the Privy Council.
Wo konyi mosa abonyoto damen ka jaba kese woto bakela Privy Council letunu wotumo.
But going to the Supreme Court was certainly very expensive.
Bari kata Supreme Court wo tembo wo bakela ku kolengol tinu wotumo adaba abakole ala.
The Court of Appeal at the time exercised jurisdiction on constitutional matters.
Katu kiti sankam bunda nyi wotumo ikakolu menu tamandi wole mu constitutional la kolu velari nyame.
But this was not in relation to matters pertaining to legality of legislations vis-a-vis the Constitution.
Bari wo mantara dendin kol la men ya lon ko lebe dendi loi lu lanya la sako kol men ya lon ko letata constitution o nyim fangoma wole mbanko la sarti buko nyi.
The reality we were faced with was that we only had the Constitution just in skeletal form because the most vital parts of the Constitution were suspended.
Ntelunga nyatili nu men na wole mku kolengoti katu o tembo Constitution o nying kukum malumenu ba kono ntelisi men sinteli sembentu ya nu ngotumo yewlu be bondile nu ngotumo yewlu tong.
And the status of each and every decree was that insofar as it is inconsistent with any provision of the Constitution, the decrees will prevail and override the Constitution.
Adu wotumo ko membe kering wala mnyinti wo decree o lumenu yelondi wonya nani constitution wala mlua sarti bukuba banko katanu menna nani wala sarto lu benta daoda constitution nyina ko wala banko la sarti buko nyi kawla ko lu landile decree nyina ko lu kawla tamandi kalo wala.
The decrees were not lawful, if you ask me. They were not lawful, but it was that order that gripped the nation and country was being ruled under that.
Nyinin ka wo dikrilu imanke luati de andu ni luwa manta bar bitungo tembo membe kering kangoni sembo wala yolu londi wala na ikatama nu wala.
Mr. Touré, precisely, I just wanted to agree with you there because that was the question I was posing to you because the Constitution at the time was the supreme law of the land. You could not have had lesser legislation which attempted to suspend its provisions. So it was clearly unlawful and it could have been legally challenged provided obviously that the right circumstances were available, which they were not.
You are perfectly right.
Amonta council kama nyinin kaja wala mnyinti ko na kum nyinin karo fon koto moleti yemen jabi teng kato tembo wo dikriolu bankola loi sarti buko nying asi balanno le wo dikriol la wala ke bay bari bitum wairi anata findi ko wo dikriol wo tembo sembo dita wollela ka tambi bankola constitutional fon la lotan kangolu la wo dalilo le asabu.
But the scenario we are faced with is that the son becoming much older than the father. So decrees where they couldn't have, in a normal setting, by any stretch of imagination, they couldn't override the provisions of the Constitution. But that is the whole idea of a military government. Wolu malodula soto sembe dula tela taran dula tela niani na constitutional la bar bitum kwal nata la nyaming amonta menu be steering menu be mararo bundala wolu yon wolna nata o decree olu fisiandi ke sembentu ya ke tambindi bankola constitutional la lotan kangulula.
Thank you very much for that.
Thank you. And then
do you know what eventually happened to them?
They were escorted to Mile 2 prisons, and that was the end of the case.
Ye dandang ye samba Mile 2 kasola ko nyin dandula keta woleti.
And then I think it was the same day I was sacked as a magistrate.
Na mera ate ulun kilung fana yente bay kambondi na palaso to ko magistrate.
The following day I got my letter.
Asomo lem yenna letter odinna.
I was dismissed, and the dismissal was from the office of from the personal management office, PMO. Andu
yembay biri letter onyina tinye aketa ko kaito nying abota do ku bunda lela memmarta banko do ku lalu bela ka fujele personal management office wala PMO.
And all it stated is that we have been directed to dismiss you from the service of the Gambia government.
Adun kango membe safari nje wala mnyinti ko ye kango le di itolu fanana puri yente bayina do ko to kabon Gambia man sakunda do ku bundala.
So I had to write a petition.
Tunata kaito safe wala mnyama memu kolu sainkan wulindi kaito ti.
I addressed it to the head of the Junta, and that's the chairman, Yaya Jammeh.
Nga letero men safe wonya nga ki Junta sojar bunda la kuntonkole wotumo wole mu Yaya Jammeh fangoti.
Can you tell us why you wrote directly to the head of the Junta instead of addressing your concerns to PMO?
Ne asabu foi sa fono nya dalilo me asabu yele taro nyin safa andu yaki me wala junta ko la junta la nyaton godi imaki me mola me alonko wala marling Gambia masakunda do gulal be la nyaton ko imaki we.
Now, the following morning, the following day in the morning, I was called to say that I had a letter, so I went to the High Court, and that was where I received my letter.
Asomo le mi yen kumandi ko nga letter o sotole bitun data High Court wotembo le mi letter o dinna.
I then went to the master, and the master said, "Let's go to the Chief Justice." So
data master ya master kongata Chief Justice ya.
But by this time it was Omar Al-Ghali who was the Chief Justice.
But wotembo Omar Al-Ghali atelom Chief Justice tinu wotembo.
But he was the one who said, "What happened? It's not right," you know. But there was so much fear in him.
Bari atele nyum fanyan ko menketa anin silo manta amanke kutilindi muti.
So
bari nak memba kono utumo ate fanambe silandinne utumo.
So he asked me to write a petition. He told the master of the High Court, then Usman Jammeh. He said he asked me to write a petition and give it to the master so that he can look at it, to vet it before we forward it to the Office of the President. He expressly said I should write a letter to the Office of the President because as far as they were concerned, Judicial Service Commission was not involved in it at all.
Kato ate Mr. Al-Ghali atele nata nyin kango fonye purunga letro safe me ya lonko wole munte fanana kumala nyatili nya letro ti petition konse safe yo baribito akoninga safe nsa di mastala memmarta kito bundala otumo ka fayna Usman Jammeh ni o letro nyin jibe aya yirika otumo isina tentendi kaki president la office oto.
Can you tell us how you were appointed?
Sa fono nya yeta do ko la nyadi.
I was appointed by the Judicial Service Commission, not the PMO.
PMO manteta do ko la Judicial Service Commission wala mkitindir bundala kafu sembe mabati bunda banyi wala enteta do ko la.
PMO has no authority over my service.
PMO man ka wo kan soton tela do ko la karola wutumo.
In fact, act of PMO even directing that letter to me is also unconstitutional.
Andu hani PMO law letero fongo ka letero bondi tella karola ka kintea ani sartolu manta nyola.
So, like he advised, he said I should write a petition. I prepared a petition. I brought it to the master, Usman. When he looked at it, the very first paragraph, he laughed.
Waira ta kunga letero safe nte fana na kolu menuti nga letero safe petition akonsa di mastala nga di mastala biriwo letero nyinna borindi follow nyin jube dorong ajeletale.
He told me, don't you realize we are dealing with a military government? I said, but if you ask me to write, I'm just expressing my mind.
Akonyam feta malon ko inin sojar man sakundale betilindi nyola teng nkai ha mambala wala bari nte fana ko membe nsondo mokono nka wala fintindi teng.
Sorry, Mr. TOURAY, can you just give us the contents of the letter in summary?
Letter on yinka sutandi don foi sa fono nye kuma kan men safeta kono ba.
Would you have a copy of it available?
Letter on yina copy be bulu jande ba.
I don't have it here now. I passed by my office this morning because after the change of government in 2016, I filed an action against the government to get a constitutional declaration that the dismissal and the subsequent termination, because I was dismissed and then thereafter later in 2000 I was also terminated, were unconstitutional. So I went to the office to try to access the file so as to bring a copy along, but I couldn't see it. But I will get it get it for the TRRC later.
Di somanda ntambital na ofiso la puru nyin kamala nsika mbulo sila kaito lukang meya lonko. Nte fango birimman sakunda falinta nun 2016 nata savero kele kaita ndi kolu menu tamata ntela karola menu ni silo manta nyola menu ni sarto manta nyola munta nga samaniro ke okuotole yo bari bitun lafta mbulo lala no kaito le kamfonsi file nyin soto ba birinna tan na ofiso to nga kata nyawnya ndi mang mbulo man lano kaito lukang bari mba kata la ngana fere ke ngaw kaito lu futandi TRRC ma nyatondo.
Were you able to find your appointment letter or your termination letter?
Ile ing bayri letter on warando yeta letter on men na foi nata na jela bang.
Yes, that's what I am saying. I have them in my case file, personal case file, that in the action that I instituted against the government. I'll make copies available to the Commission.
Ambole fokanteng ibebe na o file le kono na file ba nying yo bari mbe fere kelale mbulo ela o kaito lukang ngesa inka yelema nga fere ke han foye futa TRRC ma.
And just out of interest, how did the institution of that suit go?
Puru sulo kan rondong o ilo samanero ni safero nying akeno aketa no nyadi le.
The decision went in my favor. The dismissal and the termination were declared unconstitutional. They were, in fact, the angle from which I approached it was that they clearly amounted to an unwarranted interference in the administration of justice.
Bitumbiria ko jube ya no masata ndele nataganye akonyi nkono katubiria alanya aninkolu Kenya jibe itataja ko yekolu kemnyu nyaming ye tamandinu nyaming anin sarto manta anin lua manta nyola wodalilo le yasabu ndenata kangosoto je menketa to nyati nteganyeta akonyinto.
So this provides clear judicial precedent of interference in the judicial system by way of unlawful dismissal.
Certainly.
Please let's go back to the contents of the letter. I'm particularly interested in what actually made the Master of the High Court, Usman Jammeh, laugh.
Silang ngata letter on yindo kuma kama meyalong holbe fururu ni letter on yingono katunga yang sula bagal pur kalong mune ya sabu kabri master membe nunje ba fala me Usman Jammeh bringa damra ka letter on yin karandrong aya borondi follow yin karandrong a jeleta lefta ka wota lolo.
He was of the opinion that the letter was too radical.
Atela jero munyete ko letter on yin kuma kangolu menu bije iketa kuma kambamba ndingol leti.
He asked me to rewrite it. I did so. But when I brought it again, he was of the same opinion that it was too radical.
Akona tafo nyenga sa inkan safe ngakangolu do ngakuma kangolu faling. Nata sa inkan safe ngakuma kangolu faling bare hani o fanang biringa nate akonyeng hanimbi kukilingola bijede.
Do you remember any particular words or phrases you used?
Hakilo samu no yemu kuma kan sifa le keje memba ila mira loro memba sabu atak ba falako ila kuma kan nyingu chambo warda bagale bambanda bagale.
I can't remember anymore because the 2 drafts actually remain with him in his office. I'm sure he must have destroyed them. He was the one who finally toned down the letter. And then that was the version that we sent to the office of the president.
Hakilo te wolu mutarno la katu kumeri ngolombari nyin kayti fulolu be ngamen folo safe nata fulanja o men fanan safe wolu be labanta atele bulokono bari ate fangole nata safer ke afaye ay menki bitun kolu nata wole nyama.
After about 12 days, I was called by the confidential secretary of the Secretary General.
Do kulalu be kuntonko noma ate mo do kulale timembe wale noma ikafole Secretary General.
I went to the office of the president.
Ntata president wala office auto.
State House.
State House.
I was given a letter reinstating me back into the service of the judiciary.
Nata letter din na meye murundi kana palaso saima menketa kitindiro tamandi bundati.
Who was the SG at that time?
Well, SG, the Secretary General to Warola.
This was WADA.
Utumo membije ka fine WADA.
Do you remember his first name?
Was
it Mustafa Wada?
Mustafa, yes.
Mustafa Wada.
I remember before they gave me that letter, in the intervening period, he called me to say that I should send a second petition.
Hakilo bakang wo wuche onyin kono janning kumandir fulanja ngo bekela wala nyim fonye kongata nga letter fulanja ngo safe nyanta menkila.
I think when they start over the petition, the issue that was raised by the Attorney General then was that I should have committed Mr. Jobate for contempt of court rather than dismissing the case.
Amunta birite lusita konyin kunna ya jube iko nyanta Mr. Jobate dundila nunkito nyin kono le kafoko amunta ate jututa kiti bunda nyin nale wole fisiata nunga konyin mume obay.
Did they tell you on what basis you should have cited him for contempt?
Well, in
the course of the arguments from both sides, there were ethical issues which were observed on the side of the prosecution. So part of it filtered in my ruling. That was the reason why they said that I could have adjourned the matter and dealt with the prosecutor by exercise of the powers of contempt rather than striking out or dismissing the matter.
Apart from the Attorney General, who else sat on that petition?
Attorney General,
I believe it was the military council, and the Attorney General was a member of the military council.
And who was the Attorney General at that time?
This was Mr. Bite, Musa Ngari Bite. I sent in the second petition explaining why I could not have committed Mr. Jobate for contempt.
Ngakaiti fulanja unsafia ngaki kaitandi dalilo lumene ya kendi manya tiling Mr. Jobate la kafoka ajututa kito nyinale.
And after a discussion on that by them, then that was how I was reinstated.
Ngalong ko biritel fangulu sita ya ko jube kachata akwala inata kamben dalilo kang puruka jeko yenta murundi na doku kang yenta.
It's interesting because at the beginning you told us that the effect of some of these decrees was that it suspended legislative as well as judicial powers. And in this case, it looks like the council is sitting over your case as an appellate court looking at the merits and demerits of the case.
Nyabo warabaga komando ne yafa mole nu njanko ni decree ni nketa loi len men ya lonko loi la sarti buku ba nyi anin loi kiti bunda nyi na sembo nyi awol be talale silan afere jan junta la mol keta mol de me ya lonko wolle be siri tela kuoro ibela ko nyi kiti ka mo sa fono kiti bunda mul ngona mje fana de betela ko nyi kiti ka.
Yes, that's absolutely true, because the Chief Justice, with all due respect to him, and may I pray for the Almighty to give him, how do I put it, Jannatul Firdaus. But the entire judicial system threw in the towel. They didn't want to take any single decision over the matter.
Who was the Chief
Kiniajube akonyi mbe menu sita kunto katabula atenyim fangla memu ko kunto nkote alama nema nin kafarkelaye itelbe na tay bulo ku nyin ko nyin konole imam pare kantaman laje wo tembo ko afindita nu nyami.
So all the power was concentrated in the hands of Jammeh.
Kato tumo sembo be na ta dun jamme dam manne bulo kono.
Who was the Chief Justice at the time?
This was Omar Al-Ghali at the time.
Omar Al-Ghali atelom kolu nyaton koti wotembo.
I must also say my sacking was the first interference
Mbenyim fanam fala ko kante bayi wala keta bulubula foloti
by the executive
nyaton ko sojar nyaton ko la man sakunda e
in the judiciary.
Ke dabula wala ke bulobula kitindir bunda la do kolu
And it generated a lot of condemnation from the United Nations, from the Commonwealth, so many of these organizations.
Andon dunia la nyin kafubalu bena ta wo ko doya United Nations ana bunda ko tangulu ibeye wo doya ka foko sojar oli apare sojar man sakunda ye bulobula kiti bunda la do ko kono.
And I remember to give Sadauda of blessed memory occasion to condemn the junta. He said, now it's clear that we have gotten evidence that the junta is not sincere to whatever they are saying.
And wo kamfanan tala Alhaji Sadauda banko nyatun ka follow alama nema nin kafar kelaye atafanan nata doya roke akola ko silanga seneyata le kaitandi molu la ko nyin sojaro liye memfo ko itelube mala nyamin woning itelube keka nyamin sayin ifatatale.
So when the dust settled down, I was moved to Mansakonko.
And before the dust settled down, did anything in particular happen to the then Attorney General who had made some suggestions as to what you should have done in the case?
Janding kankan nyimbe temkunna fo kuna na sotola menketa memunu Attorney General do wato la menarana fo enyanna kule mentaman la case nyindo fo kuna na kala.
Well, by coincidence, the day I was reinstated was the day he was sacked.
Between kolu benta nyaming asike amunta bentale katu lumme yente murundi na do kola ulunna yate bay do kola.
Was that coincidence or executive plan?
Well,
let
me say by coincidence.
It's strange that it was coincidence if his advice was disregarded, you were reinstated, and then he was booted out.
That's how we saw events.
Yete murundi na yate bay ate min me alon ko yate ate yamaro dinu alaw yamaro nyingi mala yamaro ta sire inata ne ate bay yete murundi
Okay, thank you very much, Mr. Touré. I believe it's now time for the break. We'll just leave it here and then go on to the break and come back. Mr. Chairman, I hand over the witness to you.
Yes, indeed. Coincidence, extraordinary. Thank you, Mr. Touré, and thank you, Council. We will take a coffee break and come back at 12:20.
Thank you, sir.
Thank you.